Good morning and welcome back po ulit dito sa ating lecture room at dito po sa ating segment, Your Question, My Answer portion. Pag-usapan po natin or tatalakayin natin ang isang katanungan ng ating subscriber. Ito po yung galing sa ating video lecture about DAR clearance, yung land transfer clearance na discuss natin previously. Ito po ang katanungan ni Ponce. Ang sabi ni Ponce is that, does the 5-hectare rule apply to fish ponds or to a mix of farmland and fish pond exceeding 5 hectares? Advice please, attorney. Thank you. So, in short, ang katanungan niya, ito bang fish ponds, sama na po natin ang prawn farms, yung hipon, shrimps, no? It's covered by the 5-hectare retention limit, no? Kasi, sabi nga natin sa batas, Republic Act 66657, is that it is hanggang 5-hectare lang retention sa agricultural land. Okay. So, fish ponds, no? To include yung prawn farms, yung shrimp, hipon. No? Ang katanungan is that, are they covered by the comprehensive agrarian reform laws natin? Now, at first it is, but later with the amendment, is that ang fish ponds and prawn farms are exempted from coverage. So, klaro po yan, ha? Hindi po yan makakover ng DAR. For notice of coverage, bawal po yan, no? And that, kasi daw, ang sabi nila, ang fish ponds and prawn farms, sabi ng batas, is not considered as an agricultural activity. Hindi naman pagtatanim yan. Incident lang yung lupa eh. Kung mayroong lupa po at may nilagyan ng tubig at nagbuhay ng isda, aquaculture yan. Hindi po yan agriculture. Alright, doon ang concept, no? So, balikan po natin, no? Republic Act number 6657, o yung Comprehensive Agrarian Reform Law of 1988, pinasa ito noong panahon ni Curry Aquino, no? Now, this was amended, no? But before its amendment po, covered po ang prawn farms at saka yung fish pond, no? And it was amended by Republic Act number 7881. At itong Republic Act number 881, tinawag itong CARP. Okay. Kasi yung first CARL, CARL, Comprehensive Agrarian Reform Law, yung 6657, nung amendahan, 7881, on February 20, 1995, tawag po nito Comprehensive Agrarian Reform Program of the government, wherein sinasabi po doon, ang fish ponds and prawn farms are exempted from coverage as long as the following requirements are present, no? Ano po yung mga present requirements ito? Pinakauna po is that it should be direct and for exclusive use of fish pond. Direkta at eksklusibong ginagamit po para talaga fish pond at prawn farm. Hindi po pwedeng hindi siya direct and exclusive. Kasi kung may halo, gaya ng katanungan mo, Mr. Ponce, it's possible na mako-cover. Okay, but I'll discuss to you later, no? And of course, aside from the fact na direkta at ginagamit it exclusively para for fish pond at saka prawn farms, kailangan po wala pang distribution na nangyari at wala pang CLOA na na-issue sa ARB. Okay, ano ba itong CLOA? Certificate of Land Ownership Award doon sa mga agrarian reform beneficiaries. Kasi nga, sabi nga natin, nung Republic Act 6657 pa siya, covered siya. And prawn farms and fish ponds covered siya. So, it's possible kasi na merong notice of coverage at nakuha na ng government at na-expropriate at naibigyan na po ng just compensation yung maaari at pinagdidistribute na at na-issuehan na ng Certificate of Land Ownership Award ang mga agricultural reform beneficiaries. And therefore, it was done before the effectivity ng Republic Act number 788. Vested right na yun. Huwag nyo nang pakialaman yun. So, ibig sabihin, that is now considered as covered. Okay. Alright. Now, how about doon sa hindi pa may notice of coverage pero wala pa naman distribution na nangyari tapos wala pang CLOA na issue sa ARBs? Well, ang sabi ng batas sa Republic Act number 7881, yung amendatory law, ang sinasabi niya is that bibigyan po na isang taon ang mga workers, yung nagtatrabaho doon sa fish pond at saka sa prawn farms, wherein to decide whether or not ma-exempt ba itong sa coverage or i-cover ng Comprehensive Agrarian Reform Law natin. Yun po, no? And ang magbobotohan lang po sila by simple majority. Ano pa bang simple majority? Yung 50 plus 1 ba? So, if there are 100 workers, mananalo po 50 plus 1. So, 51 votes. No? Either yes or no. Kung yes, is that ma-exempt siya wala na, hindi na yan siya mako-cover, no? And these workers continues to become workers, but meron silang ibang, may scheme, no? Financial scheme na dapat gagawin nila para dito sa mga workers. Parang sort of commission, no? Parang ganyan yung sinasuggest ng batas, no? And if it is not agreed upon, or agreed upon nila na, sige, hindi ito i-cover, meaning, simple majority. Pero kung simple majority din, kung sinabing dapat covered yan, hati-hatiin yan sa amin. Okay? Diba? Wala tayong magawa. Even if mahirap hatiin ang Fishponds kasi paano mo man mapigilan ang portion, no? Paano pag-divide ng isang land na merong tubig sa loob at sa may mga para sa fish yan, prawn farms, no? So, possible po, kung hindi talaga sila magpahig na ma-exempt ito, mako-cover yan. Walang magagawa yung may-ari ng Fishponds at babayaran siya ng government. And the beneficiaries will be given a chance to form an association or cooperative. Kaya meron tayong mga Fishponds or cooperatives na meron pong pagmamay-ari ng mga prawn farms at saka Fishponds. Because of that, no? But maganda rin yun, no? And from there, kung ano yung kikita nun, paghatian ng mga members ng association or the cooperatives. So, depende. Kung ano nag-fall doon. Depende rin ang sagot ko kay Mr. Ponce mamaya, no? Sa later part, I will answer your question. Now, actually, dumating na itong issue na ito, itong prawn farm at saka fish pond sa Supreme Court, no? Doon sa kaso ni spouses Numeriano and Carmelita Romero versus Mercedes Tan, no? Ito ay nailabas ang decision in 2004, no? Sabi ng Korte Suprema, clearly, by virtue of the amendments to the CARL, the operation of the fish pond is no longer considered an agricultural activity. And a parcel of land devoted to fish pond operation is not agricultural land as therein defined. So, ibig sabihin po, kung ganun siya, hindi na siya agricultural activity, yung po kasing lupa na ginagamit na nilagyan ng tubig is just an incident, no? It's just a tool para magkaroon po ng tubig at talagyan ng isda. So basically it's considered as aquaculture. No? It's not agricultural activity. Klaro po na Supreme Court dito, ang agricultural activity yung pagtatanim. Yung pagtatanim at mag-harvest, yun po ang meaning, no? Pure farmer sa lupa talaga. Nagbubungkal ng lupa, nagtatanim. And that is considered as agricultural activity which covered ka ng batas. Okay. Ano pala nangyari doon sa kaso na ito? Because this case wherein ito pong meron pong mga workers itong napakalaking hektarya ng lupa ito. Maabot itong million of hectares, no? And there are plenty of workers here and sabi nila na well, it should be covered, no? By the comprehensive agreement at i-distribute to sa amin para magawa kami ng co-op and co-op at saka association. Eh, ang nangyari was that yung may-ari naman sabi niya hindi. Kasi itong kayo ang nag-work dyan as lessee. So nagpalabas po ng ebidensya na meron po tayong lease contract. Nevertheless, sabi naman ng mga nagtatrabaho doon, well, yes, may lease nga kami, nagrerenta kami sa inyo. However, priority pa naman ang mga lessee doon sa distribution. So, ganun din. Pwede i-cover yan sa CARP at ibigay din sa amin. It doesn't matter whether we are workers or we are lessees. Then, ang sabi naman ng kabila is that no, it is covered by the civil lease, no? Ibig sabihin, under civil law, nag-expire na po yung lease contract nyo, ay titigil ko na. Wala na, hindi ko na parentahan. Paparentahan ko na ito sa iba na mas malaki ang offer sa akin. Sabi niya, hindi. This is covered under agricultural lease and therefore, it's covered under DAR, sabi ng mga nagrenta yung nagtatrabaho doon, and therefore, it should be covered and distributed sa amin. So, umabot nga, no? In fact, nag-file ng kaso sa MTC para pa-eject. And eject naman sila kasi meron silang compromise doon na sige, alis na kami. Pero inakyat pa rin nila sa PARAB, Provincial Agrarian Reform Adjudication Board. Sabi ng mga workers, sabi naman ng PARAB, yes, it is covered. Dapat ipamahagian sa kanila. Hanggang dumating po sa Korte Suprema. Ito sabi ng Suprema, no? The operation of fish pond is no longer considered an agricultural activity. At sabi pa ng Supreme Court is that there is no agrarian tenancy relationship here. Kasi bakit nga namang magkaroon ng agrarian tenancy relationship here, hindi naman to pagbubungkal ng yupa. Kasi nga, sabi ng Supreme Court, hindi na present yung certain requirements to show na ito po is considered as agricultural land and therefore there is an agrarian tenancy relationship. Number one, dapat daw, ang subject matter should be agricultural land. Ang fish pond, hindi agricultural land. Yan ang klaro, no? And number two is that the purpose should be agricultural production. Yun, sa agricultural land, magtanim ka, let's say, ng puno ng durian, okay? At magtubo ang durian, harvest mo, and that is clearly agricultural land and for purposes of agricultural production. And there should be personal cultivation done by the tenants themselves. Okay, now, the question is, Di Ponce, does the 5-hectare rule also apply to fish ponds or to a mixed farmland and fish pond exceeding 5 hectares? So, ganito po ang aking opinion, no, Mr. Ponce, is that the 5-hectare rule applies only to agricultural land. Kung exclusive po siya ginagamit as fish pond or prawn farms, as in your case, is that hindi po mag-apply si 5-hectare retention limit. But take note po, ano po ba yan? Yang bibilihin nyo or ibebenta ninyo? Ang tanong ko is, na-cover ba yan siya before? O na-issue na yan ng CLOA? O hindi? Or nagkaroon na ba ng botohan wherein that property, as I said, within 1 year from the enactment of 7881 Republic Act, nakapagbotohan ba ang mga workers wherein sinabi doon na, okay, this will be exempted or this will not be exempted? Okay. But let's put it in general way dahil general ang tanong mo. So it is not covered. No? However, sabi mo dito yung mix, no? Mix na farmland and fish pond exceeding 5 hectares. Well, if it is mixed farmland, I believe that the farmland or the agricultural land should be covered under the Comprehensive Agrarian Reform Law. Whereas ang ating fish pond, basta klaro, directly and exclusively used, no, for fish pond purposes, is that that would not be covered by retention limit. So it's best that you get a genetic engineer to have a relocation survey to determine which is farmland per se or agricultural land per se and which is yung tinatawag nating fish pond or prawn farms, no, para ma-establish natin so that malaman natin kung ano yung covered by the agricultural what is considered as agricultural land at hindi agricultural land. Kung ma-cover ba tayo sa dito sa coverage, no, under the Republic Act 6657 yung 5-hectare retention limit. At saka important din to determine para kung any and all transactions there pag ma-consider siya agricultural land is that kailangan natin ng DAR clearance kung sakaling may sale, may transfer, di ba? So dadaan tayo ng DAR clearance. Pero kung exclusively fish pond nga siya, hindi na po kailangan kasi it is not considered as agricultural activity. So, I hope I answered your question. And guys, that is my opinion and that's how I see it. I conducted some research. Maganda kasi yung tanong niya. It's very nice, no, about fish ponds. No? And we were all enlightened. And myself, I was enlightened about these things. Thank you for such kind of questions. Yan po ang mga gusto ko na mga questions para po magkaroon po tayo ng video lecture na maganda and in relation po sa ating usapin. Maraming salamat po at magandang araw po sa inyong lahat. Sukran.